Advocate Jay Sai Deepak, and all the participants who are present with us. Without much ado, I would like to introduce the Advocates League. The Advocates League is an initiative whose work is devoted in the field of legal research, including publications, online journals, and organizing various types of competitions such as seminar and conferences. We have a team of dedicated young minds who work on legal scenarios as well. Our team consists of students and alumni from various law schools and universities of the country. The Advocates League is under the guidance of eminent personalities who are both lawyers and judges of the Supreme Court and the Honorable High Court of Delhi. Further, we are honored to have with us Advocate Jay Sai Deepak. Sir would be addressing his talk on minorities under the Indian Constitution. Now, I would like to take this moment and introduce Sir. Advocate Jay Sai Deepak is an engineer turned lawyer practicing and arguing counsel primarily before the Delhi High Court and the Supreme Court of India. Sir has a bachelor degree in mechanical engineering from Anna University and a bachelor's of law degree from IIT Kharagpur. In over a decade practice, since 2009, Sir has carved for himself a niche career in civil commercial litigation, intellectual property litigation, constitutional law, and competition law as well, and he has been part of several landmark cases in the said areas of law. He is a regularly invited speaker to many of the premier law schools of our country. Recognizing his expertise in the field of intellectual property since November 2016, Sir has been engaged by the Department of Industrial Policy and Promotion, Ministry of Commerce, Government of India as an honorary advisor on the implementation of national IPR policy. In August 2019, for his contribution in the field of law, Sir was awarded Young Alumni Achiever Award at his alma mater, IIT Kharagpur. Sir writes frequently on constitutional and civilization issues on his blog Yukti and in mainstream publications such as the New Indian Express, Financial Express, and the Open magazine. Now, without much ado, I would like to request Sir to start his talk.
Yeah.
Yes, sir.
So, thank you for inviting me to speak with the members of your group. Uh, I was supposed to deliver this lecture on minority rights and secularism at Jamia, I think about a week and a half ago, and people are aware of the controversy that surrounded it and why I was not able to deliver my talk there. So I'll not get into that issue. So I decided to limit myself to certain high-level issues with respect to minority rights, so that people have enough pointers for them to proceed to do their own research and come to their own conclusions. My idea is not here to feed my conclusions to people, but to throw up a couple of questions of research, throw up a couple of jurisprudential issues, so that they have a better idea as to what is the framework within which we're supposed to look at the concept of minority rights as far as India is concerned. So one of the things that I think we have to understand is the genesis, the jurisprudential basis of the concept of minority rights, not just in India, but across the world. And specifically the circumstance and the backdrop against which the concept of minority rights was introduced in India, and who was it actually in relation to. So if you look at the liberal theory of rights in the context of nation states, or in the context of, let's say, nation states as it has evolved from the European continent, the concept of a nation state in Europe effectively is the product of the Treaty of Westphalia, which was entered into 1648. And this is a topic that I've recently written about. And the more I read about it, I understand, and I've come to the conclusion, at least my very limited conclusion at this point, that the concept of a minority and the concept of a minority right is largely the product of a nation state as a concept. So it becomes important to first understand what constitutes a nation state and who constitute minorities within a nation state. Nation, as has been defined in the context of Europe, effectively translates to a largely homogeneous group of people who share the same cultural identity, who perhaps have the same linguistic identity, and who perhaps have the same religious identity. And this sense of homogeneity effectively makes them a nation for the purposes of the European continent. And those people who have such a cultural, linguistic, and let's say largely even religious homogeneity, when they decide to give themselves the shape of a state, when they decide to give themselves a political organization called a state, then effectively their identity as a nation coincides with their political aspiration as a state. And that is effectively what translates to a nation state. So, for instance, when you speak of France, you effectively speak of the French, and that is a distinct identity. When you speak of Britain, notwithstanding multiculturalism and its impact on the British society today, it is largely associated with Britishness. It is largely associated with a certain religious as well as a linguistic identity and even a racial identity for all practical purposes. When you speak of Germany as a country, you associate it with a Germanic identity. And the Germanic identity existed way before the concept of a German state, way before the unification of Germany, and way before even the princely states of Germany, before they were ultimately united by Otto von Bismarck. Then, when you speak of Poland, you speak of the Poles. When you speak of Russians and when you speak of the sphere of Russian influence, you're looking at a Slavic identity. When you look at Hungarians or Hungary, you're looking at a Hungarian identity. So, when you speak of Europe and the concept of a nation state, it naturally becomes important to address the rights of those people who do not share the same identity as the vast majority of the nation. And therefore, it is in Europe that the concept of minority rights had become extremely important, because the entire identity of the state was dependent on the identity of the majority of the people who had a shared sense of worldview and a shared sense of identity. So it was in that context the question was raised as to what do we do with, let's say, German speaking peoples in France or French speaking peoples in Germany, or what are we supposed to do with a state like Switzerland, which has a combination of both French and Germans as part of its social fabric. Now, it is in that context that the concept of minority rights assumed importance. And therefore, when we speak of minority rights in the context of a country like India, whose very constitution or whose very concept of a nationhood or civilizationhood is vastly different from the European concept of a nation state, it becomes very, very important whether to ask ourselves whether it would be right to adopt blindly all notions of minorityhood which are taken for granted in other continents in India as well and apply them to India. One of the things that we must try and understand, at least as far as India is concerned, is that its diversity practically makes it so difficult to give the status of a majority or a minority to any particular group. In fact, in the specific historic context of India, the concept of a minority right was largely or is largely the offspring of the demand for a separate Muslim electorate that was made by the Muslim League prior to the partition of India. Therefore, when we speak of the concept of minority rights in India, we must not limit it merely to the Constant Assembly debates between 1946 and 1950. We must go back even further. In my opinion, perhaps from 1930s onwards, when the idea of Pakistan attained a certain level of crystallization, ultimately leading to the Cabinet Mission proposal of 1946, I think May 1946, 16th of May 1946, which ultimately translated to a discussion on whether India must be separated or partitioned along the lines of two separate dominions, or should there be two distinct electorates within the same dominion, which means the Muslim electorate and the non-Muslim electorate. This was a question that was asked. And around that period between 1930s and 40s, certain mechanisms were introduced even under the British period to make way for some kind of a representation of political representation of Muslims, and therefore a concept of reservation existed with respect to Muslims even before. Okay, but you have to understand that the concept of a reservation prior to the partition and prior to independence with respect to Muslims was largely based on the endorsement of the two nation theory, was largely based on the understanding that Muslims constituted a separate nation or a separate group and therefore deserved a special treatment independent of Hindus, so that they don't feel that they're dominated by a particular group. This was the sentiment behind which that this particular idea was originally introduced. But when ultimately the discussion started with respect to the Indian Constitution. The one thing that uh, the framers of the Constitution, I don't want to use the word founding fathers because that's a term that's used with Americans. I don't think we should use that at all. And largely because the American Constitution was the product of males and males alone. I don't know if even women were allowed to participate in the drafting of the American Constitution. But unlike the American Constitution, Indian Constitution is the product of men as well as women, or women as well as men. Therefore, I prefer to use the word founding, let's say, people or founding individuals or framers of the Constitution, not founding fathers. So the founding framers of the Constitution, when they were discussing this idea, and they wanted to understand what should be the yardstick or the benchmark on the basis of which a particular group gets the status of a minority within the Indian Constitution, they realized that the concept of minority cannot be determined on religious lines alone. Religion cannot be the sole benchmark or metric or yardstick on the basis of which a certain community can be called a minority or given the status of a minority. Second, it was also understood that it makes very little sense to use numbers alone as the metric on the basis of which a community is given the status, because numbers don't define social presence, numbers don't uh, reflect social strength or social influence. Because going by that logic, Brahmins at any point of time in Indian history have always constituted a minority. Going by that logic, they must be given separate representation, they must be given separate treatment, and they must be given a separate reservation for political representation and social representation. But that has not been the treatment of Brahmins in this country, because notwithstanding their small numbers, they've always been assumed to wield a certain amount of social influence, thanks to the presence, or let's say the status that is given to them under the Hindu system. Therefore, they realize that numbers alone may not matter. So, if religion alone is not sufficient and numbers alone are not sufficient, then how do we effectively address the question of minority? Was an issue that was presented before the parliament, before the Constituent Assembly. And the one thing that they realized is, what is the purpose of protection of minorities? Let us use that principle as the basis. The principle, or let's say the thought behind protection of a minority, is a community which does not have the ability to amass numbers to effectively change the political destiny of a country, or to have a concrete and effective say in the running of a country, or with respect to policies, social policies and identity related policies, must in principle be given a certain amount of de facto say, which the law provides for, so that they don't feel voiceless. And most importantly, when it comes to those aspects of their way of life which matter to them the most and which are most closely associated with their identity, they have the ability to protect those markers of their identity so that their distinct identity is never ever submerged under the deluge of the majority. That's effectively the principle behind Articles 28 to 30, specifically 29 and 30, according to me. So, which is why, if you look at the language of this particular provision, especially Article 29, it doesn't limit itself only to religion. And for the purposes of this discussion, let me just read through this particular provision so that I make my point good and it becomes clearer as to what I speak of. So, if you look at 28, it speaks of freedom as to attendance at religious instruction or religious worship in certain educational institutions. Then, Article 29, any section of citizens. So, first of all, Article 29 makes it abundantly clear that these rights are not available to persons, which is the word that is used in Article 14 or in Article 21. It speaks of citizens. Therefore, protection of the interest of minorities, first of all, is limited to only those people who qualify as citizens. Second, it starts with any section. The breadth of the language makes it abundantly clear that any section of citizens, any cross section of citizens, whichever way you choose to slice and dice that particular group to arrive at a certain class. Okay, so section can translate to perhaps a class in the territory of India or any part thereof. That is, so when you look at in the territory of India, you're effectively looking at a national level or any part thereof, which is therefore you can either be a national minority or you can be even a state-based minority thereof, having a distinct language. So the first focus with respect to Article 29 is not religion but language, because the clear realization of the framers of the Constitution was that India perhaps has more linguistic diversity than religious diversity. And languages are common across religions, notwithstanding religious affiliation. That was something that was very clearly understood. Script or culture. So, language, script, culture of its own shall have the right to conserve the same. Now, when the word culture is used, it is possible for some to argue that the word culture has been used notwithstanding the fact that the parliament could have used the word religion. And some could say that those aspects of culture which have an overlap with religion are equally protected because culture, regardless of its origins, which is to say whether it flows from religion or does not flow from religion, must necessarily be protected. In that sense, the word culture is assumed to have a broader scope of influence than religion. So, for instance, you can be a cultural Hindu without being a religious Hindu, and you could still claim protection of your way of life, your Sanskriti, your culture, your language, your script as part of Article 29. So, it starts from the specific and moves to the general, and the most generic representation here is that of culture and not religion. This is something that needs to be understood. Shall have the right to conserve the same. No citizen shall be denied admission into any educational institution maintained by the state or receiving aid out of state funds on grounds only of race, religion, caste, language, or any of them. Now, what is very, very important is this particular provision on a regular basis, in fact, from Articles 28 to 30 on a regular basis, has been constantly interpreted as those set of provisions that grant extra sets of rights to minorities, that grant special rights to minorities, and therefore, in that sense, it has become a political trope or even perhaps a trope in popular discussion that minorities in India have more rights than the majority. One, that would be a direct violation of Article 14. It makes very little sense to come out with a particular conclusion. And therefore, the one judgment that makes for a fantastic read in this particular regard is the judgment of the Supreme Court in the TMA Pi of 2002, where I think the court had the opportunity to discuss all those provisions that relate to minority rights from Articles 28 to 30 as part of its judgment. And the court comes to the clear conclusion that assume for a moment that the Constitution effectively wanted to say that only minorities have these rights. That would have been the language of this particular provision or these set of provisions. Instead, Articles 28 to 30 effectively represent those set of rights which are assumed to already be vested or to vest in the majority. And for the sake of abundant clarification, so that minorities don't feel that there is no provision in the Constitution that expressly recognizes their rights, which is at par with that of the rights of the majority, that is the only reason why these provisions have been added. Therefore, when it comes to the rights of the majority, the liberal theory of rights and the liberal theory of constitution across the world effectively takes the position that the majority does not need express protection or the majority does not need any provision that expressly protects them because they already are assumed to have the wherewithal at their disposal to do this. Second, since minorities constitute those parts of the country or those parts of the state which don't fall within the definition of a nation because they don't fall or they don't form part of this homogeneous group which is in the majority, it then becomes important to give them a certain right and to expressly identify what is the protection available to them under the Constitution so that there is a sense of confidence that they have that their rights will not be brushed under the carpet or will not be shortchanged simply because they do not have the numbers to effect any kind of a change. That is the primary sense in which this particular provision was introduced in the Constitution. When you read the Constant Assembly debates, when you read the advisory committee reports, especially with respect to, I think, minority report would mean the Tej Bahadur Sapru Committee report. That's a document that I think is worth reading. And the other document that is even worth reading, even before that, is the one authored by Sri Motilal Nehru in 1928. Okay, so the documents that I would strongly recommend reading would be, first of all, those set of documents which were authored in relation to the Constitution, either as a preparatory document or as part of the Constant Assembly debates or advisory committee reports, which came into existence before the 26th of January 1950, or more specifically before the 26th of November 1949, when the Constitution was first adopted. So, to students of law, my suggestion would be that in relation to constitutional matters, it would help to start from the Gangotri, and you don't start reading the judgments in the first place. So, I would suggest that you read the language of the provision, and to understand the sense and the context behind that particular language, you go back to the source. which is the source as it existed before the Constitution's first amendment, which is of 1951, before the Constitution was amended. Until then, you read the provisions and the history. It gives you a clearer picture of the sense in which this particular article or this particular provision or these set of provisions were introduced. Now, most importantly, if the provision, specifically Article 29, were to be treated as a marker to some extent of the scope of minority rights available in this country under its constitution, it becomes clear that unlike other countries, especially European countries where the concept of a nation state is predominant, the focus is not on religion and the focus is largely on culture, language, and script, which is very, very consistent with, let's say, the civilizational narrative that was built around the constitution, which is to basically say that this is such a vast country with such a vast group of people with such individual and diverse expressions of culture that it would help to preserve everyone's rights, and it would help to ensure that we tell people that regardless of your numbers, this state will never ever be responsible or it will never become the instrumentality of cultural genocide or cultural domination or cultural hegemony of sorts, wherein one survives at the expense of the other. So this is a point that I think that needs to be understood very, very clearly, and people need to internalize this particular concept. Because the moment we speak of minorities in this country, in practice, it has become a discussion that revolves around a religious minority and selective religious minorities, as opposed to minorities of all hues, of all shades, based on language, script, and culture. So, for instance, if you go to Manipur, several groups, including radical militant groups, to a significant extent, they fight because they believe that their indigenous script has effectively been replaced with the Bengali script. And they have historical grievances against the Bengali language because if you talk to these people, I don't know whether this is myth, fiction, or history, and I'm not a historian. From whatever little I've understood so far, one of the reasons that there is such a strong anti-Bengali sentiment, especially in states like Tripura or in Manipur, is because they believe that their indigenous languages and their indigenous scripts was effectively replaced by Bengali hegemony, is their view of it. Whether that view is to be endorsed, whether there is any historical basis, I don't wish to comment on it. I'm merely describing the state of mind as it exists within certain groups. Similarly, if you look at certain other parts, uh, it's possible. So, for instance, in the remotest parts of Andhra Pradesh, there are small pockets of uh, people where there is a huge population of Tamilians, and their language is very distinct. It is neither purely Tamil nor is it purely Telugu. It is a mix of both. Similarly, if you go to those parts of Karnataka, you have a lot of people who speak both Kannada and Telugu. If you go to Bangalore, you don't need to know Kannada. You can survive on knowing Tamil, which is one of the reasons for the grievance there. Why is this so important? This discussion with respect to minorities and this discussion with respect to secularism forgets another aspect, that when the states were sought to be reorganized on linguistic lines between 1951 and 1956, when this discussion started, one of the suggestions that came from Sri Rajagopalachari around that particular point was that this could lead to linguistic domination and linguistic chauvinism. So the better thing would be that you divide the country into administrative zones as opposed to language based states. Because the moment you divide it on language based states, there is a decent chance that the provincial identity becomes so strong that the national identity is submerged. And the very object of integration of states, which Sardar Vallabhai Patel effectively undertook along with his right hand man, namely VP Menon, would be defeated if ultimately linguistic chauvinism prevails over national identity, national sentiment, and national consciousness. This is effectively how it has translated over the years, the more you look at it. So, uh, the point I'm trying to make is when you look at the concept of minorities, given that Article 29 starts with the focus on language, script, and culture, do not immediately veer in the direction of religion, because there is much more to the rights of minorities than the protection of religious minorities. It is not limited to protection of religious minorities alone. This is a point that I think law students of all the people must know, so that when they come out of their law schools, They at least don't come out with preconceived notions based on headlines in newspapers or primetime channel debates. It is important for you to read these aspects of the Constitution. I am not saying that religious minorities are not given any kind of protection under the Indian Constitution. I am not saying that a minority identification based on a religion does not matter. All I'm trying to say is that the disproportionate amount of attention that is given to religious minorities in our popular discussion is belied by and is completely at loggerheads with the express language of the Constitution, as well as the Constituent Assembly debates, which effectively form part of the history of the making of the Constitution of India. So there are 3 or 4 books that I would like to strongly recommend as part of this particular discussion, so that students have an opportunity to actually go through those books to make up their own mind, and they can ask themselves whether this is an agenda that I'm pushing, whether there is a specific sense behind this particular point. So let me just suggest a couple of books which I had made note of. Yes. So there is a document uh, by the name Making of the Constitution. Okay, and this particular document was published, was authored by Sri A.C. Banerjee, Anil Chandra Banerjee, and this effectively captures the period between 1939 and 1947. So this is one document that mandates serious reading because it has a lot of correspondence, a lot of documents, first-hand documents, which shed light on this particular issue. Then the other document, apart from the Sapru Committee report and the Nehru report, which I pointed out, is the cabinet mission plan is something that must be read, and the discussion in the Constant Assembly, uh, or let's say the resolution which was made on the 16th of May 1946, is something that must be read. Let me just read out uh, the basic form of the Constitution as was envisaged on the 16th of May 1946 under the Cabinet Mission Plan. And this may give you a clearer picture of what was the basic skeletal structure that the framers of the Constitution had in mind before they began their work on the Constitution. So I think this is para 15 or clause 15, where it says, we recommend that the Constitution should take the following basic form. There should be a union of India embracing both British India and the states, which should deal with the following subjects: foreign affairs, defense, and communications, and should have the powers necessary to raise the finances required for the above subjects. So, this gives you also a peek into the kind of federal structure that we originally had in mind, what was meant to be within the realm of the union and what was meant to be within the realm of the states to some extent. The Union should have an executive and a legislature constituted from British, Indian, and states representatives. So, when it speaks of states, it's obviously referring to the princely states because India was divided into British India and princely states. Any question raising a major communal issue in the legislature should require for its decision a majority of the representatives present and voting of each of 2 major communities, as well as a majority of all members present and voting. All subjects other than the union subjects and all residuary powers should vest in the provinces. Okay, as opposed to residual powers vesting in the union, the residual powers were envisaged to be vesting in the provinces. The states will retain all subjects and powers other than those ceded to the union. Provinces should be free to form groups with executives and legislatures, and each group should determine the provincial subjects to be taken in common. So, broadly, 5 to 6 points, this is what was discussed. Then, the other document which I would strongly recommend reading, there are 2 other documents which I wanted to recommend to students and anybody else who's watching this. I've just made a note of this. Yes. I would suggest, yes. So there is a document that was published in 1949. Let me just share that document. Just a second. Yes. So you have a document by the name the Indian Constitution. In fact, some of these were written by judges around that period, immediately after the Constitution came into existence. The Indian Constitution, an introductory study. This is another document that I would recommend, written by A. Rangaswamy Iyengar, who was then the assistant editor of the Hindu and himself a qualified lawyer. Uh, what I'll also do is that I will share some of these documents with the organizers of this event along with the links so that they can disseminate it and share it widely with students, and I believe they must read it. Some of these commentaries, which were written immediately in the aftermath of the coming into force of the Constitution, shed greater light as to how they were read by people who existed then, as opposed to how we choose to read it now and what kind of values and what kind of intentions do we impute to the framers of the Constitution as well as to the language of the Constitution 50 or 60 years down the line. I'm not saying that we must be stuck to or we must live in the past and therefore subscribe to only those aspects of the Constitution as it was envisaged when it came into existence. The point I'm trying to make is there are two parts of the Constitution. If you wish to depart from the original intent of the Constitution, then we must be at least honest about it and therefore say, whatever may have been the intent of the Constitution, I acknowledge it, but I choose to go in a certain direction because I believe this is the right way to go. And if you choose to do that, that would at least be an intellectually honest way of going about it. Unfortunately, the new tradition, or let's say something that has been in vogue for the last 30, 40 years, is that whatever we believe is the right way that the Constitution must take, we impute it to the framers of the Constitution and we retrospectively say this is what the Constitution always said. So to call out that part of the hypocrisy and to call out the bluff, which I believe is intellectual dishonesty, it is first important to know that at time t0, that is between 1946 and 1950, when the Constitution was discussed and it ultimately came into existence and it came into force, what was it that was discussed? What is the point of departure that the Constitution has taken, especially in relation to minorities, especially in relation to the nature of minorities, through judgments and through constitutional amendments? What is the departure that we have taken subsequently? So I would say before 26th of January 1950 is one era, post 26th of January 1950 is another era. For you to understand whether there's a departure, whether there is a change, whether the change is for the good or the bad, it's important to know what existed before, or at least as on that particular date. Now, the moment it becomes clear that when the parliament started discussing this entire thing of minorities, it is no more a discussion that is based on religion. One or two things which effectively meet the eye must raise a few red flags according to me, which is one, why is it that when we speak of minority welfare or minority commission or the minority welfare ministry, so to speak, it is on religious lines and it always pertains to only one particular religion? Is it fair? Is it constitutional? Is it legal? And in a country with such a vast diversity where almost any number of groups can claim to be minorities within the meaning of the Constitution, why is it that all these members are not being given an opportunity to decide what is good for minorities? My question is not about why one person gets to be or one particular community gets to represent the minority welfare ministry. My point is, why isn't there a revolving door there so that everybody gets an opportunity with respect to the destiny of minorities in this country? When was the last time that we spoke of a Jew from Kerala representing the minorities? When was the last time we spoke of a Parsi representing the interest of minorities? When was the last time we spoke of someone who speaks Sanskrit who represents the interests of minorities as linguistic minorities? This is a question that I think we must ask, because then this effectively takes us to the most concrete, the most mundane, the most worldly manner in which these issues affect us, which is allocation of budget, allocation of resources, reservations in institutions, autonomy of institutions, and constitution of specific bodies under legislations to protect only one particular form of minorities, which is religious minorities. So the central message, because I don't wish to burden you with a lot of information, at this point I'm trying to crystallize for you certain points which I believe would be decent starting points for research and to ask the right questions at least. What answers you come to, what conclusions you come to, that's entirely between you and your conscience and how much you wish to read. But at the very least, you must know, how did the Constitution envisage the term minority? So apart from Article 29, I don't want anybody to accuse me of reading these provisions selectively. So let's take a look at even 28 and 30 for a moment. Right of minorities to establish and administer institutions. Again, in Article 30, all minorities, whether based on religion or language, shall have the right to establish and administer educational institutions of their choice. Now, when you speak of Article 30, clearly religion is mentioned. There is no doubting it. But the one thing that becomes important is when applying Article 30 the position that we have traditionally taken is the status of a minority of a particular group shall be established on the basis of their numbers within a particular state. If that be the case, how many Hindu minority institutions exist in the Northeast? How many Hindu minority institutions exist in Jammu and Kashmir? Uh, Fine. Until today, or at least until August 2019, it enjoyed a certain special status. Now, the question should be whether in the union territories of, let's say, Ladakh and Jammu and Kashmir, what is going to be the treatment of minorities? What are the rights that religious minorities are going to get in those two provinces, so to speak, under Article 30? That's a question that needs to be asked. Also, take a look at Article 28, just so that we complete at least Articles 28, 29, and 30. No religious instruction shall be provided in any educational institution wholly maintained out of state funds. Now, when it speaks of wholly maintained out of state funds, then obviously it speaks of institutions that are maintained by the state and wholly maintained by the state. So this may be to emphasize the character that there shall not be imposition of any religion through state-based institutions, because people or children from different religious backgrounds would enter that particular institution, and therefore there's no question of imposing a certain religion. So that I understand to some extent. But let's go back to the title of the chapter that relates to, or the part that relates to Article 29 and 30. It speaks of cultural and educational rights. Now, why is this important? Is framers of the Constitution effectively realized that culture survives only if it is taught as part of education, and therefore it becomes extremely important to allow institutions of a specific character, having a specific minority identity or a specific linguistic, cultural, or even religious identity to thrive, so that children who come out of those institutions understand their religious roots or cultural roots or linguistic roots. Okay. Now, this is effectively the product of a very important realization on the part of the framers that education is the source and is perhaps the way to keep a certain culture alive, so that people never forget where they come from. And if they are not taught those aspects as part of their formative years through institutions of their own communities in a manner that these communities wish to teach their history to their children, then the community stands to lose its identity over a period of time through gradual erosion. So in an era when we speak of globalization, in an era when we speak of rapid change of definition of culture, and the definition of what constitutes a generation has changed from 25 years to 30 years, it has perhaps come down to 15 to 10 years now, because the rate of change is that high. It becomes all the more important to give effect to rights under Article 28 to 30, not merely on religious lines, but also on linguistic lines and cultural lines, because India is a melting pot of cultures. India is the cradle of the civilization on this side of the Himalayas, and there is a sphere of Indian influence. Therefore, if India does not have, let's say, the vision to keep its culture alive through education by empowering more and more groups to be able to establish their own institutions, to be able to sustain and perpetuate and preserve their traditions, then over a point of time, the concept of diversity, which has been associated with India for generations, for millennia, if I may say so, will effectively translate to a homogenized identity, a standardized version, which I don't think is what India effectively stands for. So when you look at Articles 28 to 30, according to me, there are 3 or 4 layers at which these provisions must be analyzed and understood and implemented. One is obviously the constitutional layer. But the constitutional layer itself was the product of a certain civilizational realization, a certain understanding of the spread, the weave, the scale, and the depth of India. India cannot be approached as a country, it must be approached as a civilization, and it must be approached as a subcontinent, because that is the geographic expanse and the geographic diversity, which obviously has a bearing on cultural aspects of life as well, and the ways of life of different kinds of people. Okay, so one is the constitutional layer, which is informed by the civilizational layer. Second is not just with respect to the past, but also with respect to the present and the future at the social level as well as at the cultural level, which is what kind of a society do we want in the future. My sense is Indian languages, especially, are going through a phase of decline and perhaps regeneration of a different sort because of extensive imposition and, let's say, obsession with either English or any other language as the medium of education. And therefore, the country's language policy, especially in relation to education systems, is also a question or an issue that must be discussed as part of cultural rights and linguistic rights. Because, on the one hand, if you specifically recognize the right of linguistic minorities to protect their languages and to protect their script, how are you facilitating those rights? How are you facilitating the enjoyment and meaningful exploitation of those rights if professional degrees and any form of mainstream education is ultimately acquired only in English as the medium of education or in Hindi as the medium of education as opposed to the native tongue? Languages, especially native languages, should not be relegated to ornamental use, where they are used merely for, let's say, discussions within the family, conversations within the family. And now, slowly, we have come to a point where we are thinking in English, which I think is perhaps the charam sima of deracination that a country can actually reach. So, while it is possible for me to have started this entire discussion and taken it in the direction of religion, I am trying to present before you as many different ramifications of Articles 28 to 30 as possible, and the different kind of issues that must figure as part of the discussion of these provisions. Language policy, education policy, reservation, minority welfare. According to me, everything falls within the breadth and the ambit of a discussion when it comes to minority rights. It is not just about religion. It can't be just about pitting two communities against each other for eternity. It must be about asking ourselves, how do we give effect to each of these provisions to ensure that every community which has a distinct identity of its own continues to enjoy its way of life and continue to practice its way of life, which is the sense and the intent behind Article 28 to 30, is my opinion. Uh, a topic such as this is bound to give rise to a lot of questions. I think I started off at about 7:05 and we're at 7:47. I've spoken for about close to 40 minutes. I'd like to take a lot of questions because the Indian way is not a one-way monologue where we continue to give lectures. I would prefer to take questions. So if there are questions, Adarsh, I'd request you to forward them.
Yes, so there are few questions which I've got. One, Mr. Abhishek Jaiswal has asked a question:
Right.
Does minority, does majority has no right in the constitution to protect their language and culture and etc.
Right.
As the as Article 29 uses the term only minority. So what about the majority?
So that's exactly what I was trying to address, and I hope the person asking the question was paying attention to what I said, which is that the express recognition of the rights of the minorities is not to deny the availability of similar rights to the majority, but those rights which are available to the majority without having to be written expressly are the only rights which the minority gets. So, as I said, there is no, let's say, extra layer of rights that any minority, whether linguistic or cultural or religious, gets over the majority. That is a complete misnomer, which is why I would recommend students to read the TMA Pi judgment really well, because that judgment effectively represents a culmination of several line of judgments which dealt with educational institutions. But that was one significant judgment where there was a clear discussion, according to me, and a really detailed exposition of rights of majorities as well as minority, and the court trying to address this myth that minorities have more rights. Okay, so the majority equally has rights, but you have to understand, when you say the majority, what do you mean by majority? You're obviously referring to a religious majority, and therefore you're talking of the Hindus, right? Now, when it comes to the Hindus, whether it's Tamil Nadu or Andhra Pradesh, Telangana, or between Andhra Pradesh and Telangana, different regions within Tamil Nadu, different regions within Karnataka, Maharashtra, and every part of the country, except for religion and even other than religion, there are so many other aspects where the cultural representation of a Hindu in the north of Vindhyas and the cultural representation of the Hindu in the south of Vindhyas is so different. So, for me, according to me, Hindus of specific cultural expressions, even in a Hindu majority state, according to me, can constitute cultural minorities if they speak a particular language, if they have a particular script, or if there's a specific marker of their identity which distinguishes them from anybody else. So if you look at, let's say, certain communities of priests, and having dealt with some of these cases, I can tell you confidently, some priests who enjoy the status of a religious denomination, either within the Hindu community or elsewhere, apart from enjoying rights under Article 26, also enjoy rights under Article 29 as a cultural minority, because they represent a certain way of life which is practiced by barely 600 or 700 families. That, according to me, would be the textbook definition of a minority as well, a cultural minority as well. Okay, so I would suggest that when you look at the concept of a majority versus minority, don't look at it from a European perspective, because the Indian majority or the Hindu majority is very different from a European majority, and it is an agglomeration of multiple minorities giving rise to a Hindu majority. So please understand that that is something that I've been saying over and over again at several places, that do not superimpose the European version or an alien version of minority majority on India. We are very different. Even the majority community is a majority which is an agglomeration of minorities, and therefore they're equally entitled to rights under Article 29.
So can I move ahead to the other questions?
Of course, please go on.
So there is one Miss Yukti Keshavaran. She has asked a question. Our constitution has given all rights to every person of the country who needs to be uplifted, but implementation of the rights and policies are the main problem in our country. What's your take on this?
There is no doubting that. I did not want the session to be entirely academic, so thank you for asking me such a practical question. Uh, I think what has happened is people have understood the constitution perhaps, and I'm not saying that I have the right answer to this. I'm merely trying to present what I believe is an identification of the diagnosis of the problem or the causes of the problem. I believe that the constitution is effectively seen as a document by a vast majority of people, regardless of which identity or affiliation they come from, as a document which is entirely meant for the state, for the government. So that sense of self-help and the sense of, let's say, collectivism, which is supposed to come from within the society to address certain causes, is completely lacking as far as India is concerned. There is an acute dependence on the state, from culture to politics to administration to environment and whatnot, which is partly the reason for the state of affairs, according to me. A country with a population of 1.3 billion today, or 36 crores as it existed in 1947, is always and has always been one of the most populous regions in the world, for the simple reason that the Asian subcontinent, as well, sorry, the Indian subcontinent, which includes India, Pakistan, Bangladesh, and parts of China, Nepal, Bhutan, Burma, and all these countries, is perhaps one of the most arable and cultivable geographies in the world, which is why it is capable of sustaining this kind of a population. When you have such a huge population, to expect the state apparatus to be able to deliver on everything, to be able to satisfy every group of people, to be able to do justice to every person, is practically impossible. I'm not giving the state a clean sheet. I'm not rendering the state immune from any kind of criticism for its incompetence or its inefficiency. But by definition, the state as we know it today is bound to be inefficient, corrupt to the core, because there is excessive dependence of the people on the state, which is what the state milks and produces, a corrupt bureaucracy. To a significant extent, the constitution envisaged a people who were capable of understanding their rights and who were capable of protecting their rights, and the state was meant to ensure and protect those rights. But you can't expect the state to facilitate the enjoyment of every possible right. Those conditions have to come from within the society, and that comes with education. Therefore, the role of the state in education is crucial, and if the state had managed to crack the code of education properly over the last 71 to 72 years, to a significant extent we could have addressed that particular issue. But I believe that among the huge failings of the Indian state, the single biggest failing of the Indian state, according to me, is education, which is largely responsible for the state of ignorance and apathy that we see. So any operational related issue or any implementation related issue primarily depends on an enlightened society. And I don't think we have done that so far. Next.
Okay, so moving on, there is a question from Shresh Pathak. How how we can represent the interest of every minority when we have given only limited opportunity to the minority communities to represent themselves in the parliament and other legislative bodies, especially with respect to Jew and Parsi minorities.
Now, frankly speaking, under the current system where we follow the Westminster system, unfortunately, of numbers, if you don't have the numbers, you effectively don't get representation in the parliament. And therefore, what you're looking at is parliamentary reforms and electoral reforms so that there is some kind of a representation. Now, that would effectively mean that you go back to the communal manifesto, the communal mandate that was originally under discussion, thanks to Muhammad Ali Jinnah, where he basically said that thanks to the numbers, we will not be in a position to have any kind of say in the parliament. Therefore, there must be a reservation for us on the basis of our religious identity. I'm not sure that's the best way to go forward because it will only lead to increasing communalization. Perhaps I think what may help is that the Minority Welfare Ministry and the Minority Commission could be made a bit more diverse in its composition so that there is representation from true minorities, not just on religious lines, and there is a greater allocation of budgets across the board because each time any government is in power, regardless of which party is in power, it is asked as to what has it done for minorities. They come out with their numbers and statistics of budgetary allocation only for one community, as if that single community is the sole minority in this country. We are not a Hindu Muslim country. There are multiple religions in this particular country. And that is something that most dispensations forget. So I would say that at the very least, when it comes to allocation of resources, if you start making a beginning, perhaps you can then start thinking of representation or future ways of parliamentary representation at some stage. I don't have an immediate answer to that question at this time. Next.
Yes, so the next question is from Madhav. Why Minorities Commission is not providing the legal definition of minority as it has neither been defined in the Constitution nor by the Commission. It only says that less than 50% will be minority, so 50% of the state population or whole of India.
Can you repeat the question, please? I'm so sorry. Can you repeat the
Yes,
question?
sir.
Let me
Yes, sir.
just.
Question is from Mr. Madhav. Why Minorities Commission is not providing the legal definition of minority as it is neither been defined in the Constitution nor by the Commission. The only definition, by definition, it means that if you're less than 50%, then you will be considered as minority. What is your
So one is, I think it's important for us to certainly look at this in terms of definition, and I think there are a couple of judgments which are useful in this particular regard, which set out the metrics for who or what constitutes a minority and what are the circumstances in which they can be treated as a minority. Let me just share some of those judgments for the sake of the students so that they can go back and read them. Um, yeah. So Bal Patil versus Union of India of 2005. Then TMA Pai is another judgment. PA Inamdar versus State of Maharashtra, which is of August 2005, again of the Supreme Court. And DAV College versus State of Punjab 1971 is another judgment that I think is mandatory reading. In addition to that, I would also suggest reading Naresh Agarwal versus Union of India, which is of 2005 again. Perhaps this may be uh, a good starting point to understand what is our definition of a minority. One, if a definition is absent in the Constitution, it doesn't prevent the Minority Commission from coming out with its own definition. But I think this is largely a political question as opposed to a constitutional or a legal question. Because the moment you choose to come out with the definition of a minority, I would suspect that there are bound to be multiple forces, both centrifugal and centripetal, so to speak, where people will try to push and pull this commission in multiple directions. If I were to be asked for my suggestions, according to me, the following factors would be important. Numbers, yes, but numbers not alone. The numerical strength alone is not sufficient. Representation in public administration, economic strength, okay, and representation in public employment, and social representation. Is there any active boycott or ostracization of a particular community? Now, it's not possible to go entirely on the basis of social representation or, let's say, representation in public employment for a good reason, because by inclination, some communities may be more inclined to take up business as opposed to taking up public employment. And some may not be interested in contesting elections, but some may be more interested in funding people who contest elections. Therefore, any single aspect as a marker of somebody's position as a minority may not be sufficient. Clearly, this is something that is dependent on a cumulative collective consideration of multiple factors. Others is finding something funny. Sorry, you're on mute.
Sir, it's the questions. The questions
Ah,
which are coming in.
okay, I hope they're
So
provocative. Go on. So I'll take another three, four
yes, sir.
questions.
It's just
Yeah,
because of that. Yeah.
yeah.
So there is a question now. I don't know whether you would be speaking on that. It's about CAA,
Huh? No,
and
it's got nothing to do with minorities. I'm not discussing that.
okay, sir. So
Questions that are
then,
strictly relevant to the topic are the only questions. People shouldn't use this opportunity to push in everything under the sun.
yes, sir. So that is why exactly I was laughing.
Ah.
So there is another question.
Let me just answer this question.
Yes, sir.
CAA has got nothing to do with rights of minorities in India. Period. Move on.
Yes, sir. So now there is another a very good question which has come in is about the culture and the language protection,
Hmm.
which is not often used. And if it is used, can it be used by the majority of the population also? So suppose you're in Hindu
Of
and you
course.
want there is a script which you want to protect. So can you enforce that under the minority umbrella or not?
That's what I said. If the majority in India cannot be treated as a monolithic majority, they are culturally, linguistically diverse. And therefore, every community within the Hindu fold itself has the right to protect its identity as a minority. Okay, so for instance, Sanskrit speaking villages or Tamil minorities in a Telugu speaking state or Kannada minorities in perhaps Gujarat, whatever you may want to call them, or Parsis in Gujarat or Parsis in Bombay, or let's say in Maharashtra, not Bombay anymore, of course, Mumbai. So it is possible to use the rights and let's say freedoms guaranteed under Article 29 for communities even within the Hindu fold, notwithstanding the fact that Hindus are a majority on an all India level, they may not be a majority in every state. Okay, because it was recently publicized, I think that at least in 8 states in India, Hindus are minorities and therefore they are entitled to the same treatment as other religious minorities in other states. Unfortunately, the Supreme Court dismissed that petition without giving it an opportunity to be heard and without issuing notice to the respective state governments. That was indeed surprising. So the answer to your question is yes. Unfortunately, that is not the reality that meets one's eye on the ground. Next.
So the next question is from Ms. Niharika Sharma. Sir, can you give your views on the reverse discrimination which is happening with the majority in the name of secularism?
Right. It's good that I did not speak on the topic because I'd be seen as pushing a certain agenda. It's a good thing that the question has been asked. So there is a clear case to be made that the Sachar Committee report is a textbook example of reverse discrimination against the majority and was specifically based on false premises. And to the extent that the then Prime Minister Manmohan Singh made a statement that the minorities of this country, and specifically one religious minority, has the first right of resources, or first right on the resources of this country. I think that was a blatantly discriminatory, communal, and polarizing statement to make. And it is my case, and I strongly believe, I don't care who thinks what, that secularism in this country is effectively nothing but pampering of certain vote banks. It is Tushtikaran of the first order, and there is no running away from that. And in the process, what has happened is it has only contributed to more communal polarization and more communal conflagration as opposed to communal cohesion. Therefore, uh, any minority which truly deserves to be protected must be protected under the Constitution through legitimate means. But to constantly exaggerate a victim complex in the name of protection of minorities, I think is only ruinous in the long run. And not only it destroys harmony, it is bound to sow the seeds for another round of civil attrition in this country over a long period. Maybe another 15, 20 years, our generation will have to bear the brunt of this nonsense.
Yes, sir. So these many questions we had received.
Okay, ठीक है. Is that it?
So yes, and it's almost time as well.
Okay. So we managed to finish it in an hour. Good.
Yes, sir. So now I would like to propose the vote of thanks.
Yeah.
Firstly, I would like to thank you, sir, for your valuable time. Then the core committee of the Advocates League, the convener, Mr. Nitish Kumar Mishra, the president, Ashish Kumar Rai, further Legal Sarcasm for their support. Legal Sarcasm is a venture under Spread Law Society dealing in the field of legal journalism. The daily news blog covers all legal aspects from the perspective of social, political, and economical and other technological issues. Mr. Hemant Srivastav, he has joined us is the president of the Spread Law Academy. Further, now I request each of the participants also they can write to us that how we can improve our webinars series in the link which is given below, and the Advocates League would be coming up with more such events and webinars. Thank you, sir, for joining us.
Thank you. Thanks a lot.
Sir,
Thanks for
any
the opportunity.
yes. Thank
You
you,
have
sir.
to tell me more about yourself, though. I don't. I remember meeting you, but I hope it's right for me to ask this question. I
Okay, sir.
usually get the distinct impression that the student organizers and presenters don't get an opportunity to talk about themselves. So I think that there should be a change. So please introduce yourself to the audience.
So my name is Adarsh Kothari. I'm a fourth year law student at Amity Law School, Noida. I am
Okay.
associated with Think India and the Advocates League. So, sir, Think India was the first time we met.
Okay.
So the
So
Ram Mandir thing, which
I
went
understand.
viral on YouTube.
Where I was wearing a particularly pink kurta, I remember.
Yes, sir.
So, to law students, I just have one suggestion, and perhaps as someone who has spent close to 11 years in the profession, I have just one sincere. I don't call it advice. Let's think of it as a suggestion. Uh, do not let newspapers and popular discourse detract you from the course of legal research and the skills of legal research that you're expected to pick up, because when you do your research is when you sharpen your ability to ask the right questions. To me, there is no such thing as a right answer, but there's always something as a right question. So my distinct impression over the course of the gazillion webinars that I've done over the last 30, 40 days is that students perhaps are not reading enough. And there is a decent chance that students are being encouraged to be spoon fed. Okay. Which is why I consciously chose not to spoon feed you here, except to give you the sources which you're supposed to read and understand and come to your own opinions. What I think this generation must be in a position to do, considering that you don't have the baggage of your fathers and forefathers who were living under the license Raj, because we come from that generation. I come from that generation where our parents were the product of 1940s and 50s, and therefore there was a certain amount of baggage that they carried. At least this generation must have the ability to produce original thought which emanates from this land and is consistent with the spirit of this land. That is my only suggestion. And that is not possible unless and until you arm yourself with the basic ability to collate facts and to make sense of facts and to connect various dots. That would be my humble request to students. Whether you pursue a career in policy, in academia, or in litigation, or in transactional lawyering, or whatever form of lawyering, this will always hold you in good stead. So please focus on reading more, and please focus on articulating whatever you read in the form of writing as much as possible, because there is no substitute to scholarly writing. With this, I'll end my pravachan. Okay.
Thank you so much, sir.
Okay. Thank you.